I want to thank y'all for being here this morning. I wanted to comment very briefly on the actions of the Madison County Grand Jury yesterday. The grand jury met on the case involving the death of Kingston Frazier. The grand jury returned indictments in that case. I wanted to comment briefly on the charges for which the grand jury returned indictments. Byron McBride was indicted on one count of capital murder. The indictment alleges that Byron McBride did kill Kingston Frazier during the commission of the crime of kidnapping. There was a second count that was also returned against Byron McBride. That count was for possession of stolen property, being a 2000 Toyota Camry. The value of that property being more than $1,000 but less than $5,000. Against D. Allen Washington, the Madison County Grand Jury returned a 3-count indictment against Mr. Washington. The first count of that indictment being accessory after the fact to murder. The second count of the indictment being accessory after the fact to kidnapping. And the third count of the indictment being accessory after the fact to motor vehicle theft. Against Mr. Wakefield, the grand jury did not return an indictment but returned a finding of probable cause, and I will have a copy of that finding of probable cause which I will make available to you in just a few moments. The grand jury, in their finding of probable cause, found that there did exist probable cause to return indictments against Mr. Wakefield for accessory after the fact, for accessory after the fact to kidnapping, and for accessory after the fact to motor vehicle theft. The grand jury also found that at the time the crime was committed, Mr. Wakefield had not yet reached his 18th birthday. He was 17 years and 9 months at the time of the crime. Because he had not yet turned 18, and because this crime is not a crime that carries a life sentence or involved, at least his part of the crime, involved a weapon, that original jurisdiction would lie with the youth court of Madison County. But the grand jury made further findings, and it says, and I will read, and again this will be provided to you before you leave here today. It says, the grand jury, pursuant to Mississippi Code 4321-151, finds that exclusive original jurisdiction for the above listed offense rests with the youth court of Madison County. The grand jury hereby respectfully requests that the youth court of Madison County take all available actions to certify the above named individual as an adult and thereby transfer this case to the circuit court of Madison County. The grand jury believes it to be in the best interest of justice that said defendant be charged and tried as an adult for his involvement in the death of Kingston Frazier. At this time, our office has contacted the Madison County Youth Court. We are arranging a meeting Monday between investigators from the Mississippi Bureau of Investigations and the youth court prosecutor so that they can begin the proper proceedings in youth court. The hopes of our office, the hopes of the family, and the findings of the grand jury would be that the youth court would ultimately certify Mr. Wakefield up to circuit court so that Mr. Wakefield's charges could be resolved in circuit court and that he could be held accountable and would be held accountable as an adult versus his case remaining in youth court. As y'all are well aware, youth court is a closed proceeding. So outside of me being able to tell you the findings of this, any other matters relating to youth court will remain sealed until some findings are made by the youth court judge. What distinguishes Mr. Wakefield from Mr. Washington, because as you may recall, Mr. Washington was also under the age of 18 at the time he committed his portion of the offense, is that Mr. Washington was already in circuit court by way of an indictment for an armed robbery out of the city of Richmond. And once an individual is under indictment, then any charges which would have occurred after that indictment, original jurisdiction would arise with the circuit court. So I wanted to make sure that I gave a proper explanation as to the outcome of Mr. Wakefield's case, as to why Mr. Wakefield's case and Mr. Washington's cases, even though they were both below the age of 18, were treated differently, and also to make sure that we expressed our desire to see Mr. Wakefield's case ultimately transferred back to circuit court for him to be certified as an adult so that his cases could be tried in Madison County Circuit Court. Do y'all have any questions that I might could answer?
When do you expect arraignments for McBride and Washington?
Possibly as early as next week. The indictments have been filed against Mr. Washington and against Mr. McBride. The Sheriff's Department will be coordinating with the Circuit Clerk's Office and attorneys for both Washington and McBride for both the service of the indictment and then any sort of arraignment process. So that could happen as early as next week.
Is Washington still being held without bail?
He is. He was out on bond at the time he committed his offense. He was out on bond for an armed robbery, so the Constitution allows the state to seek to hold an individual or to see that bond is denied on the new offense. So that is why Mr. Washington will continue to be held without bond while Mr. Wakefield was entitled to post bond earlier this month.
And he's still out on bond?
Yes, sir. At this point, he is still out on bond.
Is he still in the county?
I do not know.
You didn't, when you released him, didn't have a condition that he had to stay?
Not in Madison County, no ma'am.
Okay, does he have to stay in the area, do we know, or?
The judge or the court did not put any specific requirements on his location. That will be between he and his bonding company.
Are we going to seek the death penalty in this case?
We've not spoken to the family on that. We did speak to the family for several hours on Tuesday before the presentment of this case to the grand jury on Wednesday. During that meeting, myself, and this is Brian Buck, I did not introduce him earlier. Brian is one of the assistant district attorneys in Madison County, has been working very diligently on this case. Brian, myself, and other members of my staff did meet with the mother and father of Kingston Frazier, explained to them what we expected the outcome of the grand jury to be. We've not yet had a conversation with them about whether or not we will seek the death penalty, but as the case continues to progress along, that decision will be made, but it will be made after we've had an opportunity to consult with them and seek the family's input.
Does your decision lie solely on what the family wants, or what do we think it may be?
It would not lie solely on the input of the family, but that is very important to us. It would rest upon, not only the facts of the case, what aggravators that we think that the state would have in this case versus mitigators offered by the defense. I would tell you that this would be a case that, looking at it on the outside, would merit the death penalty being solved in this case. But again, I don't want to make that decision alone without seeking the family's input.
Does his age, the fact that he's 19, would have anything to do with the fact that we may or may not seek the death penalty?
No, because he's over the age of 18, he would be eligible for the death penalty. And so the fact that he's young, that would be a mitigating factor that the defense could try to use at trial to convince the jury to spare Mr. McBride's life. But it would not be a major factor that our office would take into consideration.
Yeah, that's what I was asking. For you, the fact that he's 19.
No, ma'am. That would have very little input or factor very little in our decision-making process.
Why are the accessory charges the right charges for Wakefield and Washington?
Without going into the details of the case, the facts of the case, based upon the investigation, based upon interviews, based upon statements given by Wakefield and McBride, based upon cell phone records, GSR tests that were performed, surveillance video that was reviewed. It is our opinion that neither Mr. Washington nor Mr. Wakefield was present when Mr. McBride shot and killed Kingston Frazier. We do believe that they assisted him after the killing had occurred by driving him away from the scene and not reporting this to law enforcement. And so, looking at all the facts together, we reached that decision that this case, or the cases against Mr. Washington and Mr. Wakefield, that their actions actions were accessory after the fact versus accessory before.
Could the grand jury have returned an indictment against Wakefield? Was that possible?
They could have returned an indictment against Mr. Wakefield for capital murder. They could not have returned indictments against Mr. Wakefield for accessory after the fact.
Did you say that Wakefield, the recommendation on Wakefield was on the kidnapping and auto only, and not the accessory to murder like?
No, sir. The grand jury, if they would have had the ability, would have returned indictments against Mr. Wakefield for all three charges: the accessory after the fact to murder, accessory after the fact to kidnapping, and accessory after the fact automobile theft.
Do you expect either Mr. Wakefield or Mr. Washington to plead guilty and cooperate to testify against Mr. McBride?
At this point, it would be too early to speculate. There have not been any conversations in which there's been any agreements with either Mr. Washington or Mr. Wakefield to plead guilty and offer testimony against their co-defendants. So at this point, we will allow the case to continue to proceed, but I would have to say that looking at the involvement of the three individuals, that Mr. McBride would be the individual that we would target first in the prosecution of this matter.
Has he expressed, and I'll excuse him, has he expressed why he killed him?
I really can't talk, don't feel proper talking about anything that was said in any of the interviews or any of the statements that were made. Would like to try to keep the pretrial publicity to a minimum if at all possible. I know there's a lot of information about this case that was already out at the preliminary hearing, but as far as commenting any more about specifics of the case or anything of that nature, I just would prefer not to do that at this time.
You expect a change of any?
Again, that would be up to the defense. Of the early on, Mr. McBride was represented by the capital defense team, public defenders group out of Jackson. I anticipate that they will probably continue representation of Mr. McBride, and then it would be up to them to choose whether or not they wanted to file for change of venue.
How has working with Hinds County been? Are they going to conduct their own investigation? Will these individuals face charges in Hinds County?
I can't speak. I will say that, very early on there was a great cooperative effort between JPD, Hinds SO, NBI, Madison Sheriff Department, Madison PD was involved. You had the State Crime Lab, the Medical Examiner's Office, the FBI also became involved at some point doing some analytics for us or on this case. So there has been a great cooperation among law enforcement to see that these cases be worked and that ultimately these three individuals be brought to justice. I've not had any recent conversations with the Hinds County DA's office as to whether or not they intend to seek any additional charges.
What does the autopsy show as to the number of times that Kingston Frazier was shot?
Again, I don't want to comment on any of the evidence at this point, other than to say that the autopsy did reveal that he died of a gunshot wound.
When's as soon as this could go to trial?
As soon as the indictments are served and there's an arraignment, there will be a court date set. It would take somewhat longer to get Mr. McBride's case to trial. If the state does seek the death penalty, there will have to be some delay for the gathering of mitigating evidence. But we hope that we will have initial trial dates set sometime, maybe summer, on at least Mr. McBride and Mr. Washington. It remains to be seen how long the process will take for Mr. Wakefield's case to make its way through the youth court system.
Summer 2018?
Yes, ma'am, that's correct.
What are the maximum sentences that Washington and Wakefield can face as adults?
The sentence for accessory after the fact to murder is 20 years. The sentence for accessory after the fact to kidnapping is 20 years. And the possible maximum sentence for accessory after the fact to motor vehicle theft is 5 years. So it would be a total of 45 years on all three of the charges combined.
Do you know, is Mr. Fortner still Mr. Wakefield's lawyer?
Yes, to my knowledge, Mr. Fortner still represents Mr. Wakefield, and then Mr. Warren still represents Mr. Washington. Any other questions? Was asked earlier about the indictments. Until they're served, I cannot provide a copy of the indictments. Once those indictments are served on Mr. McBride and Mr. Washington, those indictments then become public record and will be available to you. But I do have here the findings of probable cause, which deal with Mr. Wakefield's case. All right, thank you all very much.
Thank you.
All right, do you expect those indictments served today?
I don't know, but they were just handed down yesterday.
They're in jail, we know where to find them.
Yeah, so that would be up to the sheriff's department. They generally try to coordinate the service of those indictments when their lawyers can also be present to go ahead and waive that. So most likely that would be early next week.
Okay.
Thank you.